Hi, welcome back to our third segment. This time we are talking about property law and a review of property law as we know it. Now, I'd like to think of property law not just as a movable property, but also goods as well, or movable property. So, what's the difference between a movable and movable property? Now, you must have studied this in some detail in your property law classes. Effectively, if if an object is intended to be fixed permanently to the earth and then used, then it would be considered as a movable property. However, if the intention of the property is to be moved around, then that would become a movable property. Effectively, anything that is permanently affixed to the earth happens to be a movable property. Anything that is not permanently affixed to the earth is considered to be movable property. So why is this important for us? The clue lies in the Sale of Goods Act. The Sale of Goods Act defines goods as inclusive of shares. In other words, shares are goods. And because shares are goods, anything that applies to goods applies to shares as well. We'll come back to this when we are asking the question as to why do we need to do a due diligence. If you don't know what a due diligence is, that's perfectly all right. That's what we're here to learn. So in other words, the right to property encompasses three basic rights: the right to use the property, the right to alienate the property, and the right to possess the property. Let's take a few examples of this. Let's say I have an apartment somewhere in Delhi. I have the right, and I am the owner of that apartment, which means that I have the right to sell that apartment. I have the right to sell it to another party, a buyer. Thus, doing so, I am exercising my right to alienate. I can also put that apartment up on lease, which means that I am handing over possession of that apartment to a tenant. While the tenant is in possession of that apartment, I cannot regain possession without giving adequate notice. At the same time, I'm also allowing the tenant to use that apartment. I cannot be using that apartment while the tenancy is still in place unless if I have prior permission from the tenant. In this case, when I'm executing a lease agreement, I'm handing over possession as well as use of that property. Now, what about the right to use only? Well, I can invite somebody over to my apartment, and if they need to use the washroom or they need to sit down and have a meal with me, I'm giving them the right to use my property as shelter. I have not given them long-term possession of my property. And this is where the distinction between use and possession comes in. Possession is usually exclusive in nature. When one person is possessing immovable property, it is only that person who will be able to use and possess it at that point of time. Which means that when you are using your hostel rooms or your dormitories, you really don't have possession as such. It's more of a license agreement with whoever owns your dormitory rooms or your hostel rooms. So in other words, in terms of an immovable property, if I'm alienating the immovable property in its entirety, I am also giving away the right to possess and the right to use that property. This is done through a sale deed. If I don't want to sell my property, but I simply want to hand over possession and use, then we execute what is known as a lease deed, not a sale deed. And if I want somebody to use my property but not have exclusive possession over that property, we would enter into what is known as a license agreement. All three of these conveyances or documents you would have studied in some detail in your classes on property law. Now let's understand and let's apply our understanding of these three rights in property to goods. Now, again, you have the same rights in movable property as you would have in immovable property. So now, if I am selling my mobile phone to somebody, I no longer have the right to use it. I no longer have the right to possess it. And I certainly don't have the right to sell it anymore because I've already sold it once. And therefore, a standard sale of goods takes place. However, I can also transfer the possession of my good along with its use to a contracting party. This contract is known as a bailment, where somebody else has possession of my goods and might have the right to use it as well, depending upon the terms of our contract. However, if somebody comes along and says, hey, my mobile phone battery is dead, can I use yours to make a quick call? I simply hand over my phone so that this person can make a quick call. Now, this isn't really handing over possession as such, because I'm right there, I'm in the vicinity, and I can take it back at any point of time. So we see that the three rights that apply to immovable property also apply to movable property, in the sense that for a good to be alienated, we call that a sale of goods. For possession in a good to be transferred, we call that a bailment. And we can simply lend our mobile phones so that other people can use them. Now, interestingly enough, we can have part transfers of both movable and immovable property for the purposes of securing a loan. Let's talk about loans a little bit. We've all borrowed money at some point of time, or we've lent money at some point of time. And we know the difference between a secured and an unsecured loan. A secured loan is where there is some kind of valuable property that is given to the lender so that if the borrower does not return the money back, the lender can use that property, sell it off, and use the sale proceeds against the loan amount. We've all seen how this works in, let's say, car loans. I go and buy a car and I approach a bank for a car loan. The bank says, all right, out of the 20 lakhs, we will give you 15 lakhs as a loan. So now I have received 15 lakh rupees from the bank as a loan. I transfer this 15 lakhs to the car dealership and I get a brand new car. But it doesn't end there. The bank will ensure that I enter into something known as a deed of hypothecation. What that means is, what a deed of hypothecation does is that it allows me to use the car, to possess the car, but it stops me from alienating the car. I can alienate the car only when the bank has approved of the sale. So what's happening here? I have transferred to the bank the right to sell the car, but not the right to possess or use the car. Those two rights remain with me. If I don't make good on my equated monthly installments or my EMIs, the bank can come into my residence and can take the car away. Similarly, this could also work for an immovable property like an apartment. Let's say I've taken an apartment and I've taken out a home loan. Again, through a regular home loan, what is happening is I'm able to use the apartment, I'm able to possess the apartment and enjoy it, but I don't have the right to sell the apartment. I will be able to sell the apartment only when the bank has agreed or has confirmed that I can, has given its approval. Now, would you call this a hypothecation? Absolutely not. A hypothecation applies only to movable goods. The equivalent of a hypothecation for immovable property is known as a mortgage by the deposit of title deeds. Now, you would have studied the various forms of mortgages in property law. These would include an English mortgage, a simple mortgage, a usufructuary mortgage, a mortgage by conditional sale, an anomalous mortgage, or a mortgage by deposit of title deeds. In the real world, most mortgages of immovable property, whether they are of residential, commercial, industrial, or institutional nature, so it doesn't matter whether it's an apartment, a shop, a factory, or even a university, all of these mortgages that are carried out are done so through the deposit of title deeds. How does this work in reality? If the bank holds the title deeds to your property, you really can't sell your property because whoever you're selling it to will want to see the original title documents which say that you are the title owner. So in other words, a hypothecation and a mortgage by deposit of title deeds are pretty much the same, except that hypothecation applies only to movable goods and the mortgage applies only to immovable property. Now, how about a situation where I have taken a loan, I've handed over possession as well as the right to sell the property? What is this known as? This is known as a pledge. In other words, I am creating a contract of bailment on movable goods. I'm creating a contract of bailment, and I'm telling the bailee or whoever's holding possession of my goods that if I don't repay back your money, you have the right to sell my goods. Think of this as a loan against deposits of gold, right? Let's say Muthoot Finance. What they do is they will take your gold and they will give you a loan in exchange. If you do not repay the loan, they will use that gold that you've given them and they will sell it to repay the loan to themselves. They will use the sale proceeds to set off whatever loan dues you have. This contract, or this kind of an arrangement, is known as a pledge. A similar kind of contract exists for immovable property as well in terms of a simple mortgage. All right, so effectively, what we have done in this segment is that we've covered the various kinds of contracts that apply to movable and immovable property. We've seen how property is effectively a bundle of three rights: the right to use, the right to possess, and the right to alienate. I can transfer these rights either in their entirety when I'm selling my property, or I can transfer these rights piecemeal. I can also transfer these rights piecemeal to secure a debt. This has been the segment of our review of property law. In the next lecture, we'll be going on to the basics of company law.